All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in Knoebel versus Knoebel. It's our cause number 1 CACV 220405FC. Counsel, we've read the briefs in this matter and we've conferenced it today. Please keep that in mind when you present your arguments. Both sides have 20 minutes to do so. Appellant, if you wish to have any time for rebuttal, it's up to you. But it's your obligation to make sure that you keep your time. And with that, when you approach the podium, if you'd please announce the party that you represent as we're recording these proceedings. Counsel, you may begin.
Thank you, Your Honor. If it may please the Court, Christina Cervone on behalf of Eric Andrew Knoebel, who is the respondent/appellant in this matter, and I would like to reserve 5 minutes for rebuttal. What I'm ultimately asking the Court to do today is I'm asking the Court to overturn or overrule the ruling as it relates to child support, spousal maintenance, regarding the division of one of the debts, community debts, and the attorney fee award. The issues regarding child support and spousal maintenance somewhat go hand in hand, and it's specifically related to how the court attributed or how the court factored in father's income. The court in its ruling factored, well, based off of what I see from the ruling, because it's not 100%, I don't believe that it's 100% clear what the court used to find father's monthly income. When you look at the child support section of the court's ruling, the court basically says he uses the Arizona child support guidelines and then refers to the child support worksheet. In the child support worksheet, there is a number. And that number, it appears to have been derived from the testimony.
Well, what is the number? Let's start there.
Sure, Your Honor. And I want to make sure I give you the exact.
It was about $12,500, wasn't it?
Yes, Your Honor.
Okay. So he used a number of $12,500 per month. Mm-hmm. And so if I understand the testimony correctly, that represents both income he would have received from the business and proceeds from the business. Is that correct?
That is not actually what the testimony was, as I understood it, based off of the report from the expert. And according to the court's ruling, if you have a second, I can pull it up and I can pull the exact wording from the judge on where he found the income. He, in essence, basically said he derived this income basically off of the testimony of father and mother's expert's testimony on what his monthly draw is. And that's father's expert didn't testify to what father's income was.
Okay, so let's go with what mother's expert testified. And didn't mother's expert testify that there was income from the business and what would be reasonable compensation to him? It's not a trick question.
I don't believe that the record is actually clear on how.
Well, isn't that approximation? I'm going somewhere with this.
I understand that, Your Honor, and I don't believe how he came.
Well, let's
to that
assume
number.
it was.
Okay.
He ordered the business sold.
Correct, he did.
All right, so how can you factor in business income if the business has been sold?
That's correct, too, Your Honor. That was going to be my next point, was that, well, first off the business.
Well, you didn't even want to give me that he included business income.
Well, I hadn't gone there yet, Your Honor.
Okay, so did he include business income in arriving at the $12,500?
Yes, he did. He included all of it was business income from the business that he ordered sold, and the business that was also owned by both parties.
Well, the business was the business receiving $12,500 a month?
I don't believe it was, Your Honor.
So it had to be $12,500 a month plus something else?
Correct.
It included something else.
Mm-hmm.
Okay. Is there any evidence in the record that would support a $12,500 a month without business income for father?
I don't recall seeing anything in the record that supports that, Your Honor.
What is in the record that would support a reasonable income for father absent the business income?
It would have been his testimony or based off of what his AFI said he had made previously.
And how much did he make previously?
If I could go look at the AFI.
I think it was about $4,000.
Approximately that, Your Honor. Prior to the business, yes. It was approximately $4,000 to $5,000 a month is what he reported he was making.
And didn't, I believe it was, mother's expert who testified that there was approximately, in a market survey, it would be about $7,000.
I apologize, Your Honor, I couldn't hear you.
In a market survey about his education or what he was doing for the business without business income would be approximately $7,000.
$70,000?
$7,000 a month.
Yeah.
Is that what the court should have used? Is that your position, that the court should have used that $7,000?
I think that the court should, if the court was going to use the business income.
I'm not talking about business income. I'm now talking about what his marketability was as a job outside of the business.
I don't think that he should have used the expert's opinion because the expert was an expert on business valuation. The expert wasn't an expert regarding his ability to earn income. That would be a different type of expert. That would have been an expert who would have looked at his background, looked at all of his education, and determined what was out there in the marketplace. So the only number the court could have used was what my client purported on his AFI of what he had previously earned.
But that was like 12 years ago, wasn't it?
Approximately that, Your Honor, yes.
Well, doesn't that need to be updated?
Yes, but that would have been then that should have been through a business, not a business evaluator, but through somebody who can come in and do an assessment on that.
But isn't that your client's burden to provide that information?
I guess technically, yes.
Where did the $5,000 come from?
So I know that during the time that he was running the business, that's what he was pulling out each month was approximately $4,000 to $5,000 a month that he was like drawing out to pay some of the expenses. Some of the expenses were also being run through the business. But even so, if the court was to rely on record and wanted to use what Mark Hughes' testimony would be about what somebody in his position would make, that still is $7,000 and not $12,500, what the court used.
But it seems to me like the parties presented the trial court with a binary choice. It's either $5,000 or $12,500. Why was it an abuse of discretion for the trial court to go with the $12,500 under that situation?
Because I don't think the facts ultimately support that, though, where they came up with that money or that amount isn't actually supported in the record. And the trial court is expected to still follow the child support guidelines, and the child support guidelines say, when you're dealing with business income, how to determine that.
And how do you determine that? That's the gross?
That's basically gross receipts minus ordinary and reasonable expenses. So at the very least, that could have been used as well, which doesn't equal that.
I think what we're struggling with, though, is once the business is sold, why is that even a valid indicator of what father will earn moving forward versus what he would earn as an employee of an equivalent business?
And I can understand that struggle. And again, I think that if the trial court was to look, though, at his earning history, I understand it's 12 years old, but he did have an earning history that was presented to the court.
So can you go back a bit? How do we know that the court did or did not account for the sale of the proposed sale of the business in calculating an amount? I mean, that we don't expect that to take 10 years, do we? Or I don't know if the business is sold. It's not in the record. You can't tell us. But assume the business hasn't sold yet. I mean, isn't that something that the court should have considered, being that that's any income?
And if the court was to do that, Your Honor, I would agree that he could use what that number is, but at the same time, he also ordered that mother was to receive half the proceeds, the monthly proceeds.
Well, I understand that, but husband would receive half the proceeds, so that's part of the pot
Correct, but
of money.
But the trial judge didn't do that. He attributed 100% of what the monthly income would be, earning income from the business would be to husband. He didn't attribute anything from the business monthly, on a monthly basis, to mother.
Okay.
So I'm not sure how that is reasonable and equitable. If you're going to order a business to be sold, and then at the same time, you're going to attribute all of the income to father, but yet you've ordered the business to be sold and mother to receive half of the proceeds. So that
And
needs
it's
to
your
be done.
position that none of that income from the potential sale was attributed to either party?
What I'm saying is that he used the net proceeds from the business ultimately, because that's ultimately what Mark Hughes testified to, what the monthly net proceeds of the business was that would be given to father. He didn't, if you look at his report, he gave 100%, sorry, my mouth is getting dry, but 100% to father. He didn't attribute anything to mother, and it's undisputed that mother owned half of the business. And the court did order for the business net proceeds to be divided. So why wasn't that then factored in? Based off of how the ruling lays out, you have to look at the spousal maintenance section to determine ultimately how he determined father's income, and he said it was based off of both experts' testimony and based off of the monthly draw. When reality is, Mark Hughes is the one who testified to that.
And that was mother's expert, because I could not
Correct.
find in the record where your expert,
My expert was hired to deal with the business appraisal, and that's what Mark Hughes was hired to do as well. And so that's what she dealt with. So ultimately, that is why I'm asking the court to remand back down so we can determine appropriately what father's income is, what mother's income is, and how it should be dealt with appropriately following the guidelines. Additionally, there was a debt between the parties that was owed to father's parents. Mother did not dispute that the debt existed. She just disputed and stated that she didn't know anything of, like, how much the debt was, the time period, and there wasn't a promissory note presented, although there was.
well, I'm not sure in reviewing the record, I'm not sure I agree with your characterization that she did not dispute that a debt. Didn't she, in essence, believe it was a gift?
I don't believe she
She
actually
didn't
ever
believe there
said
was
that.
an obligation to repay it. That sounds like a gift to me.
Okay.
Doesn't it?
Well, I think that was a self-serving testimony, Your Honor. I mean, there was records to show that the business had been paying on the parents' mortgage, which is ultimately paying back the debt. It was clear in the record. She's an owner of the business. She has access to all the records. She was aware of it. She testified that they discussed it. So that one statement is very self-serving, Your Honor.
That may be true, but isn't it the Superior Court that gets to determine the credibility of that statement?
Yes.
And so if we defer to the trial court's credibility, then don't we have to affirm his order that there was no debt in the sense that it needed to be repaid?
I believe that there was enough other evidence to show that there was a debt there. And the court can review, I know you can't reweigh the evidence, but you can review the evidence and determine if it was a reasonable conclusion.
And the debt was the debt of the community or the debt of the business?
It was ultimately a debt of the business, but the court declined to attribute it either way.
It's a community business, though.
Correct. So it's ultimately a community debt that wasn't factored into any of the business.
Right, but I guess my point is if it's a debt of the business, you would expect to see some documentation of that at some point in time, a tax return, a financial statement, something indicating that this business actually had incurred this debt. And that doesn't exist, right?
Not that I'm aware of, Your Honor. The other issue that I'm raised with the court is regarding attorney fees. I believe that the judge abused his discretion with regarding ordering attorney fees. First, he states that he awarded her attorney fees based off of my client's alleged allegations that my client mishandled the business ultimately. He didn't use those exact words, but ultimately he was addressing conduct that was before the litigation. Additionally, he said that father at the last minute changed his position as it relates to the selling of the business. Nowhere in the record does it show that my client ever stated that he did not want to sell the business. In fact, father, there is in the record that shows that father sent an offer a month before trial asking for the business to be sold. Mother is the one who took it to trial to ask that the court award the business to him and to actually basically award him a business that he wasn't wanting to keep. And that, so I don't know how that was a late change in position and how it was unreasonable. And so I'm asking the court to remand on that as well. I believe the court abused its discretion on that regard. And that's pretty much what our issues are and what I believe.
All right, would you like to reserve the remainder of your time for rebuttal?
I do, Your Honor.
All right, thank you. Counsel?
Good morning, Your Honors. James Schmillen on behalf of appellee Lisa Marie Knoebel. There was a question that was asked by you, Your Honor, where you asked, how can you include the business income if the business was ordered to be sold? And if you look at the divorce decree, the business is ordered to be placed up for sale within 90 days of the order. And if you look at the trial testimony of Mr. Hughes also testified that he believed that the business would be difficult to sell for multiple reasons, business practices, bookkeeping practices, that sort of thing. So there could be potentially 6 months, 9 months after the decree was ordered before the business would be sold.
But that's not what he did here. He could have said, I'm going to order that you pay spousal maintenance or child support based on this amount of income until the business is sold. But that's not what he did. He said, you're going to pay this amount of income for 2 years.
Well, we're talking about child support income and then we're talking about spousal maintenance income, and I think those are two different things. In terms of child support income, we can modify child support at any time there's a substantial and continuous change of circumstances. So rather than order saying until the business is sold, as soon as the business is sold and father is not able to find commensurate employment and he could manage another motorsports dealership or do anything, but at that point in time when the business is sold and that income stream stops, then he can always modify child support. It's very simple to do, and then it's consistent with the purpose of the child support guidelines, which has the children supported pursuant to the parent's ability to pay.
Until the business sold, wasn't mother entitled to half of the proceeds, the business proceeds?
No, actually, the decree says in there was argument made about mother being entitled to 50% of the income. The court declined to rule on that and said, when the business is sold, you guys can deal with any offsets for income or that sort of thing. If you guys can't resolve those issues, come back to the court. And
Oh, don't tell me that, because it doesn't sound like it's a final order.
Well, the trial court said it was a final order, but I agree with you, Your Honor. It does leave a lot to happen in the future. But I think that's consistent with spousal maintenance can always be modified. I mean, it's modifiable spousal maintenance, and it can be modified anytime there's a change of circumstances. So I think it is consistent with Arizona law.
I still don't see how you can include business income in determining one party's determination and still order the business sold. Because he anticipates, in reading that, he being the judge, that anticipates it be a while before Mr. Knoebel is going to be able to earn $12,500 a month, right? Isn't that what he said specifically in the decree?
He said he recognizes that there could be a lag before he earns that.
But he nonetheless he found that as being the basis for the income.
Yeah, and I,
So where's he supposed to get the money?
well, once the money stops, he can modify, and then whatever his income is, he can pay it then, because the guidelines will make it commensurate to his ability to pay.
Can you find, is there any case that says that what you would believe would support that position, that you can enter anticipatory awards like that? I thought we weren't supposed to do that.
there's cases out there that say, and I think it's Gutierrez, that says that you can't base spousal, and I think that's a spousal maintenance case, you can't base the income based off of future speculation. I think that was a retirement issue, Judge, and I'm...
Well, you're right on the money, it does. It says we don't base it on future speculation, we base it on current ability. So I don't see any reason why he could not have found $12,500 per month until the business sold, but I don't see how he can order $12,500 a month after as a continuation for 2 years. Can you help me so I can see that?
And, Your Honor...
He's speculating about what his income is going to be after termination, and he's not basing it on a market study, he's not basing it on anything, he's basing it on the business having the proceeds, or him having the proceeds from the business,
Right,
which he's ordered sold.
right. And I guess, and I don't know what he was thinking, Your Honor. All I know is that there is a way that it's not inequitable to father, because he always has the ability to modify, and I think the court was inviting the parties, if they had any issues with income and division of business income, to come back to the court and he could address those issues.
It sounds like a speculative order to me. Doesn't it sound that way to you, counsel? You're not going to make 12.5, but just do the best you can. Isn't that kind of what he said?
Well, he's going to make 12.5 after the decree is done. He has 90 days to put the business up. For that 90 days, he's going to make the 12.5, at least. I mean, who knows? There was unreported cash revenues and all kinds of things going on there, and that was all factored into the analysis, but he would have the ability to at least do that for 90 days, and depending on when the business sold. But I guess a different way to approach it could have been, you pay this until the business is sold, and then I'm going to do a prospective child support worksheet of this is what happens once the business is sold. I've never seen an order like that, and I'm not aware of any case law that precludes the judge from doing that, Your Honor.
But that's not what he did here.
Correct, Your Honor. That is not what he did.
So what he did here was not defensible.
I don't know. No, I think it is defensible. I think it's consistent with the purposes of the child support. The best interest of the children is the paramount
Okay,
consideration.
but let's talk about spousal maintenance.
Okay.
Is it a speculative order as it relates to spousal maintenance?
No, because it's the same thing. I don't think it's any different than Gutierrez, because Gutierrez, they said, yeah, you may retire or your income stream may change in the future. And, at that time, when it does change, come back to the court and modify it. And that's exactly what Gutierrez did. And I think that's what the judge is inviting here. And the next thing we talked about was the debt. And I'm just trying to address the issues. I don't know if these are the issues that the court would like me to address, and I'm certainly willing to be redirected. But in regards to the debt, there was no evidence presented. It could have been very easily shown, the paper trail showing the mortgage transfer to the party's account and bank records. No bank records were provided, no testimony from the parents, no amortization schedule. And the judge did say in the decree, and even in his questioning a mother, she seemed to be very confused about the debt and the terms of it. But like you said, Your Honor, we defer to the judge's determination of credibility, even when there's conflicting testimony regarding a certain issue. In regards to spousal maintenance, I know in the brief they carried the child support income and the spousal maintenance income into kind of the same sort of analysis, and I think they are different. Spousal maintenance income is not the same as child support income. I know the pending guidelines before the legislator specifically state that, but even in the case law, there is, in determining income, you're not bound by the same sort of restrictions in the child support guidelines. I know there were some issues with the court's consideration of the factors, and I believe that father's issue was more disagreement with the court's determination of those factors rather than the court neglecting a factor. And
not to keep going, replowing old ground, but Is there anything in this record that would support how much father can earn absent the business proceeds?
In the trial exhibit 90, and that's the business valuation, but then they also did an analysis of both the net income and then what they did is an owner compensation. The owner compensation is what his research indicated someone could make running a motorsports dealership. I don't see any reason why he couldn't manage or run some sort of dealership.
And how much did did your expert attribute for that?
I believe it was, in the final number at the end was about 100,000, Your Honor.
Around 7,000 a month, correct?
Something like that. And I think the final number, because he annualized it, but the 3 months, I think it was right at 100,000 annually.
Was there any other evidence in the record about what father might make if he's not an owner of this business?
No, not that I'm aware of.
That's it, right?
That was, it was the Mr. Hughes's testimony and then mother's testimony about the standard of living and, you know, their expenses that were paid through the business. Lastly, in regards to attorney's fees, I don't think there was an abuse of discretion. I think there's both a financial disparity regardless of what number, you know, if we want to look at Mr. Hughes's number of what someone makes, you know, operating a motorsports dealership, or even as the owner of this business, there was a disparity of income, and that basis alone is enough to award fees. And then the court also found unreasonableness, and I don't see anything in the court's determination that was an abuse of discretion.
Did the court hold it against father for operating the business in a lackadaisical manner?
One could read the order to say that. I think the court was what the court was trying.
Would you agree that would be improper if the court intended to do that?
Right, but I think what he says is because of the way father ran the business with unreported cash revenues, underreported bank deposits, payment of personal expenses, it cost mother a lot of extra expense to go ahead and determine what that income was. Father would like everyone to believe it was $5,000 based off of his AFI with no pay stubs attached and his testimony.
Doesn't the fever statute require that it be related to the proceedings?
I believe so, yes.
So are you telling me that he ran that business with anticipatory intent to run it up during the proceedings?
No, that's not what I'm saying.
So even if what you're saying is true, that that's what the court was saying, that his your words, lackadaisical management of the business, that would be improper to consider unless it was done with anticipatory intent of the proceedings.
Yeah, I mean, I guess that'd be correct, but that's not the only reason.
Okay, now you've said that one was wrong. Let's look at the other one. Lack of adequate documentation. What is he referring to there?
And I wasn't a part of the trial, but my guess is how they had to go into the business and figure out all these underreported incomes, all these personal expenses. Could have been the unsupported AFI. I mean, father testified, yes, my pay stubs are provided. There was no pay stubs provided. It was a completely unsupported AFI. It could have been the lack of documentation for the loan. He provided his parents' mortgage statement. No other amortization schedule, no bank statements, no tracing analysis, nothing. The record is replete with instances where father failed to provide accurate documentation or complete documentation.
But again, if he's, and I don't know what he's referring to either because I only have the cold written record.
Right.
But if he's referring to things that didn't deal with the proceedings, then it would be inappropriate to say your lack of documentation.
Only if the documentations had nothing to do with the proceedings. like I said, I think there's plenty of evidence in the record that shows that there was plenty of lack of documentation during the proceedings, and that would be unreasonable and supportable under the statute.
To make a bare claim that's not supportable.
I'm sorry.
A bare claim. The loan. There's a loan, but there's no documentation.
Yeah, I mean, that would be unreasonable, yeah.
Okay, what about the last one?
And I'm sorry. I
His
don't-
relatively late change of position with respect to disposition of the business.
Yeah, and
Was there a late change? Well, let's start with, was there a late change?
yes,
When did it change?
I believe it changed pretty close, right before trial or shortly after he got.
It was stated in the pretrial statement that he wanted to sell the business.
Right.
So it would have had to been before then.
It was before the pretrial statement, but after Mr. Hughes completed the business evaluation, and he was unhappy with that number.
Why is that? I'm sorry, but how is that unreasonable to say, yeah, I just don't want to fight over this, just sell it?
Because she had to incur the expense to value a business. Had he said, hey, I don't want to fight about this and just sell it, she would have avoided the expense of the business evaluation.
So once you get discovery back, you say, oh, this is not worth fighting over, just sell it. That is unreasonable.
I believe the judge, in his opinion, thought it was unreasonable.
And didn't the trial court require father to pay for part of the expert report fees, separate and apart from the attorney's fees award? So, and wouldn't that account for the situation you're talking about?
It would, but besides the attorney's fees that had to be incurred, dealing with the expert, you just don't turn an expert loose. There is some attorney time involved. And if you look, the amount requested, I believe, was only 66% of the actual fees incurred by the attorney, and that was like roughly $24,000. And Ms. Knoebel was only awarded $7,500, a small fraction of the fees and costs incurred.
Is there, and I'm going back to late, the late change in position. Where was it stated that he actually, he did not want to sell the business? Is there anything we can point to that would support the trial court's determination that he didn't want to sell the business and then he changed his position and wanted to sell the business?
Yeah, I thought I put it in my answering brief. If you give me a second.
Sure.
Your Honor.
You have 3 minutes and 34 seconds, actually.
Okay. And okay, and then I think it's in the trial transcript at page 151, lines 9 through 16.
Say it again.
Yeah, trial transcript, page 151, lines 9 through 16.
Okay.
And when and I believe it was his counsel asking, why are you asking the business to be sold? And he says, I don't agree with the valuation number. I don't want to buy a business at that price that has no value. I believe if I walk away, there is no value. And I only did it for my family. My family is disbanded.
Well, that doesn't tell me that he always had that position or that he changed his position and came there, right?
Right.
Well, and that's my question. The trial court said you changed your position.
Mm-hmm.
Well, in order for there to be a change, we have to be able to look at the record and say, yep, this is where it was. You originally didn't want it sold, and now you do want it sold.
And I think there was a letter presented at trial where they were
Okay.
talking about settlement offer, and they were talking about splitting the value between his expert and
I thought that was your mother's letter. The way I read it, it was his
a
mother's
settlement.
letter. So that's what she wanted to do.
right.
Does that indicate that he changed his position?
No, it does not.
Is there any other evidence in the record that he changed his position?
Not that I can think of the top of my head, Your Honor, no.
Just one more question.
Yes.
Why wouldn't a business valuation have still been necessary or at least helpful to provide an equitable, to give the court the tools it needed to provide for equitable distribution of all the property? If the court didn't know what the value of the business was, and how would the court factor in spousal maintenance and child support without knowing having any idea what the value of the business was. So didn't it, regardless of husband's position of wanting to sell or not sell, didn't it add some value to the process?
It absolutely did add value to the process in terms of trying to figure out exactly what father's income was. So some sort of,
But not to the overall value of the business, you disagree?
because
with
the
me.
market would dictate what that value was if they
I
asked you to be.
understand, but what if it took 3 years to sell it? Then what? But no, just parties are just sitting back, well, we don't know if it's worth 10,000 or if it's worth $1 million
Right.
without some kind of, I don't know how the court would account for that. For child support? I mean, that's the problem. We don't know what the court
Right.
really accounted for. So, okay, thank you.
Thank you. Unless your honors have any more questions for me, I have 25 seconds. I will rest.
All right, thank you, counsel.
Thank you.
Any final word?
As it relates again to father's income, I do believe that the court's order is very speculative based off of how it was worded and how he determined that amount because he used the business income.
It's now unclear to me whether mother is entitled to 50% of the business income until it's sold. So can you provide any clarification on that for me?
I can, Your Honor. Hold on a second. Let me just grab that. What the court ordered specifically in here on page 13 of the court ruling, it said that the business shall be placed on the market for sale within 90 days of this date. The court also said, as further ordered, the parties shall divide the net proceeds of the sale of the business or shall equally share any remaining debts and related expenses not covered by the sale proceeds. And then it goes on to talk about the fact that he was going to decline to rule on the regarding assets, income, debts, and goes into what the parties should do to present evidence in regards to that. Nowhere in here did it say anything about equalizing out the income, monthly income, and based off of the fact that it said the parties shall equally divide the net proceeds. That is, to me, inferred that as it's being sold, that the net proceeds need to be divided monthly. But nowhere in here what Mother's Counsel stated is not actually in the record. That's not what he ordered. He didn't order for the parties to submit anything after the fact that they were going to dispute whether or not they were owed money over the time. It's basically divided. As it relates to the attorney fees and unreasonableness, I do want to point out to the court that both parties had to, prior to the trial being set, had to affirm that they were ready to proceed to trial. None of the parties filed any type of motion to compel or requesting any type of documentation further from father to say that he lacked presenting documentation. As it relates to the business valuations, the parties early on, which is in the record, they had obtained a business evaluation while they were going through mediation. So they already had one. Mother didn't like the value of that and then chose to hire Mark Hughes, which forced father to then choose to have to go get a rebuttal report. Mother's the one who chose to hire Mark Hughes. They already had a business valuation. So the mere fact that father was supposedly unreasonable as it related to that and somehow required mom to go get a business valuation is actually not based off of the facts of the case. They already had a business valuation. Mother didn't like the value of it, so she obtained Mark Hughes. That's not father being unreasonable. And then also as it relates to Exhibit 109.
But specifically as it relates to the court's order, is there anything that specifically says father changed his position?
In the court, that's what he said.
I know that's what the judge said. My question to you is there evidence to support it?
No, Your Honor, there isn't. And in regards to that letter, which is Exhibit 109, it clearly said this is the letter from Mother's counsel to Father's counsel, and it talks about the letter that was sent on October 7th of 2021. So at least a month prior to trial, they were very much aware that father wanted to sell the business. But nowhere in the record does it show that father ever said he didn't. And the mere fact that you get a business valuation in and of itself doesn't mean that the parties are not wanting to sell the business. And a lot of times they do get business valuations to determine what is the best course of action. Do we sell it? Do we keep it? Do I pay out? It's just the same thing as sometimes people do when they have a marital home. Do they refinance it? Do they sell it? What's going to be the best economical outcome? So to penalize a party for changing their position, even though the record here doesn't show that father changed his position, but in general, to do that is abuse of discretion, because a party has a right to change their position as long as it's a legal position that they can take. And a party can take a position of whether they want to sell it or they want to keep it, but they have a right to change that. It would be different if he said one thing in his pretrial statement and then 5 days later went into court at trial and said something different.
We addressed the notion that father can just seek to modify child support or spousal maintenance once the business is actually sold?
Yes, father can do that, but there's a process to that, and mother could still dispute his income, and the court still has the ability to attribute his income at something different than what his new income is, and that can take a long time to modify income. And the court didn't state in here that father could do that. The court said you have to pay spousal maintenance at this amount for 2 years.
The rules state that father can do that, so why does the trial court have to expressly set that?
I think that if the
order?
court was taking that into consideration when he made his ruling, he would have asserted that and would have said, I'm making this ruling. I know that father is no longer going to have income, but once he gets his new income, he can come back to the court and modify the spousal maintenance. So therefore, I'm ordering this. But that's not what the court said.
All right, counsel, thank you for your presentation here today and your briefs. We'll issue a decision in due course. The court's in recess.
Thank you.